I'm hitting record right now, and okay, we're all set and ready to go. Good afternoon, everyone. Very excited to have everyone here and excited to host a Chris Bratton today. Chris is an experienced estate planning attorney, and I really wanted to have someone with his experience and expertise to come in and answer some of these questions that I'm usually getting from my senior clients on a regular basis. So Chris, thank you so much for joining us and giving us your time, and we would like to welcome you. And if you can just share with us your experience, how long you've been in this line of work, and anything else that you think is important.
Sure. I'm an estate planning, state administration, elder law, life care planning attorney. So on the estate planning side, it encompasses creation of wills, trust, whether that be revocable trust, irrevocable trust, depends on whether it's for tax planning purposes or asset protection planning purposes. And then estate administration, we assist clients with probate of wills, making sure the estate is administered properly, filing of federal 706s, if there's a federal estate tax, New Jersey estate tax, New Jersey inheritance tax, Pennsylvania inheritance tax. So assist clients through that. And then on our elder law side and life care planning side, we assist clients, again, through that continuum of care. So our model is a little bit different on the life care planning side. We handle all the legal needs, making sure they have enough money to kind of get through the needs that they're going to require. On the healthcare side, whether that's in-home care or assisted living or skilled, making sure that they can afford it, Medicaid applications, things of that nature. But we also have an RN on staff, a social worker on staff, another elder care coordinator on staff. They're all certified dementia practitioners. So we have a healthcare advocacy piece to what we do. So those elder care coordinators, we call them ECCs, they assist the client through that continuum of care. So if they need assistance at home with in-home care, we help coordinate that for them. Or if they have to transition from a rehab into an assisted living or into a skilled setting, our ECCs help identify which places are most appropriate for them, help with that transition. Again, making sure they can afford it. What's going to be the payer source? Is it going to be private pay? Do they have long-term care insurance? Or are they going to need Medicaid? Things like that. So we've been doing this for about 19 years now. We have offices from Mercer County down to Cape May County. So we cover quite a wide area, and then over in Pennsylvania as well.
Cool. So it sounds like your office is not just handling the legal side and the paperwork, but it's more of encompassing of everything that has to do with providing as many senior resources as possible.
Right. We try to make sure that we look at the client holistically, because the problem that I was having before we adopted this model was I would handle the legal side of it, but then clients would come back and say, well, mom went into the hospital. Where should we go for rehab? Where do we go after that for assisted living? What's the best place for care? And I didn't really have the legal side didn't really address those medical issues. So then that's when we came up with this model, and we have our first EC was a social worker, and then an RN, and then we just kept going from there. So yeah, the idea is to take a look at the client holistically and meet all of their needs as they age.
Got it. Okay. Well, let's start with some of the things that, I'm looking at it as a professional because I work with a lot of seniors, but I'm also looking at it as a daughter who has parents that are heading in that direction. And I am of a mind of planning and staying ahead. So what I wanted to ask you is, what do you recommend in terms of what documents should we help our parents, or the seniors should have prepared ahead of time? What are your suggestions?
Well, at a minimum, there's 5 basic documents at a minimum. You need a will. The will is going to determine where your assets pass. If you don't have a will, there's something called intestacy laws that every state has. And those laws will dictate where your assets go. And it may not go to the individuals or charities that you want them to go to if you haven't planned ahead. So a will, which will handle the assets. Now you could have a revocable trust as well. The revocable trust is going to avoid probate. Probate's really not that big of a deal in New Jersey. It's not court supervised like it is in some states. But if you have assets in multiple states, if you have real estate, let's say you have a house in the Poconos, and then you have a house in New Jersey, or maybe you have a house in Florida and a house here, then you really need to consider a revocable living trust. So you don't have to go through probate in multiple states. But you can have either. A financial power of attorney, typically hear it referred to as a general durable power of attorney. You're going to need that to conduct financial transactions. So if you become incapacitated, someone needs to be able to handle those affairs for you. A healthcare power of attorney. So if for some reason you are not able to make your own healthcare decisions, then we need someone to be able to make those decisions for you. And ultimately, the physician is going to determine whether you're capable of making your own healthcare decisions or not. A living will, which is going to set forth what your wishes are with regard to artificial life support, mechanical respiration, trach, feeding tube, those types of things if you're in a permanent vegetative state or an irreversible coma. And then a HIPAA release, which most people don't consider. HIPAA stands for Health Insurance Portability and Accountability Act. It's a medical privacy law that says that no covered entity is allowed to release your protected healthcare information without a release in place. So if you go to the doctor now, he makes you sign a HIPAA, but that's for that doctor. What happens if you're incapacitated and you're transported to a hospital and you go in unconscious and you can't sign the HIPAA? The hospital is not allowed under the HIPAA regs to disclose what's going on with your treatment or anything to anyone unless there's a HIPAA release in place. So we need that in place as well. Now, that being said, really everyone should have these documents, even if you're over the age of 18. So what if you had a son or a daughter that's going off to college and you don't have a healthcare power of attorney in place or a HIPAA form in place for them? What if they get into an accident? That hospital, wherever they are, they're not going to tell you anything. The school's not going to tell you anything unless you have these documents in place, because once you're over the age of 18, you're an adult.
Interesting. I actually wanted to go back to something that you said about owning real estate in different states. If, for example, you have a house down the shore, but you live in Pennsylvania, but you also have another house in Florida, and you pass away and you're trying to make plans for that real estate in Florida, does that real estate, because it's in the different state, falls under the guidelines by that state, or is it under guidelines of where you physically live and resident of whatever the state?
If you have a piece of real estate in Florida and you die a New Jersey resident, you still have to go through Florida probate to take care of that real estate in Florida.
Okay. Interesting. I actually heard about everything except for the HIPAA release, but it makes sense based on what you're telling me, because we all have to sign it every time we go to the doctor. Okay. Right. Interesting. What are your thoughts on, from what I understand, and correct me if I'm wrong, there is a 5-year look back on assets. What we're talking about is, I guess, qualifying for state and federal assistance, right? What does that mean? What does that look like? What's important to know about that?
So if we're talking about long-term care, there's really 5 ways to pay for or help pay for long-term care. Either you are private pay, meaning you have enough assets and income to be able to pay for your care, whether that's in-home, assisted living, skilled, whatever the case may be, for the rest of your life. Or maybe you have long-term care insurance that will help pay. Or potentially, if you're a qualifying veteran, the VA may provide some assistance, but there are guidelines to that. Medicare will pay for a very short period of time, no more than 100 days max. The first 20 days are paid in full, and then days 21 through 100, there's a copay per day by the patient. And then typically the default then becomes Medicaid, and then Medicaid pays for long-term care. Now, Medicaid is a means-tested program, so you have to qualify. They look at assets and they look at income. So if you're a single applicant, you cannot have more than $2,000 in your name to apply for Medicaid. If you're married, there are different rules for that, and that, depending on how deep you want to go, that could be quite a discussion. But when you apply for Medicaid, Medicaid is going to look back 5 years. From date of application, going backwards 5 years, they want to see records of all your financials. They're going to look at what's been going into the accounts and what has been coming out of the accounts. And if they see anything that's coming out of the accounts that would constitute you giving something away for less than fair market value, then that's going to result in a penalty. So everything is added up during that 5-year period. If it's considered a gift, that's going to result in a period of disqualification, which is the penalty period. So from the date you apply, they could assess a penalty. So let's take an example. If mom gave away $100,000, maybe she gave $50,000 to her son to help for a mortgage. Maybe she gave $25,000 to her granddaughter for a wedding, whatever the case may be, gifts, Christmas gifts, whatever the case may be. And typically they look at anything over $500. So they're going to look at a lot of it. All that's added up. And so let's say it's $100,000 total within the past 5 years. Medicaid's going to plug that into a formula. That formula is going to come out with a number, roughly 9 months. So from date of application moving forward 9 months, Medicaid says, well, we're not going to pay because you gave away $100,000. So then the question becomes, well, who's going to pay the facility for those 9 months? Are the kids going to pay? You know, what's going to happen? Is the facility going to be out of money? Is the facility going to ask the resident to leave because they can't pay? So those are all things that we want to take a look at to see if we can help the client fix that problem. And there are ways that we can do that so that the client does receive Medicaid, the facility still continues to get paid, but that's what the 5-year look back is. So the 5-year look back isn't the same as a penalty period. There's always a 5-year look back. There may or may not be a penalty period depending on what the client has done within that 5-year period.
So do you think that in the planning and preparation, since they only look at 5 years, if you are doing the planning for a longer period of time, to go ahead and, sign the house to your children, so that way it's not there for that 5-year look back period? Does that make sense to do?
So you really have two issues going on there. One is certainly if you can plan ahead, it's always better to plan ahead. And it doesn't mean that we can't help people protect assets during that 5-year period. We can, and we do that all the time, but it's certainly better to plan ahead and know what your plan is moving forward. We always want people to have a plan. Whatever your goal is, we'll help you meet that goal during that time frame. But let's address the issue that you brought up regarding giving the house to the kids. My opinion is it's never a good idea to give the house directly to the kids. We would much rather utilize a trust to do that. So if you want to protect the house and you want to get it out of your name, that's fine. We can do that. Let's use a trust to do it, because there are a number of issues. You being in real estate, you know this. Mm-hmm. Whenever you give the house to the kids, now they take your basis in the property, which could be very low, especially with an elderly person that bought that house 40 years ago. So you're going to have a carryover basis. So ultimately, when the kids sell the house, it's not their primary residence. So now there's going to be an increase in capital gains tax. So that's not a good idea. It's not a good tax strategy. Number two, whenever you give the house to the kids, you have no control over it whatsoever. If they want to sell it, they can sell it. What happens if the child dies? What happens if the child gets a divorce or files for bankruptcy? Now you have your house in a situation that you can't control. Maybe it's subject to equitable distribution. Maybe it's subject to a bankruptcy proceeding. Maybe your son dies, leaves it to his wife, and maybe the wife doesn't like you very much and she kicks you out of the house. So it's not a great idea to leave it directly to the kids because there's too many unknown factors. We can control most of those factors if we utilize a trust.
Got it. What if instead of signing it off completely, they put the kids on the deed, right? Where it might be parents and the child, we do it 50-50. Is that considered part of the assets for the 5-year look back period?
It's still considered a gift
Okay.
during that 5-year period. So in that situation, again, the kids are going to get a carryover basis as it relates to the 50% transfer. And then mom or dad are going to retain that other 50% interest. So it's still not a great tax strategy. And you're still opening yourself up to those other things that we discussed. So the trust is typically the better route to go.
All right. So which leads me to the next question, which is the trusts. What is your general opinion on having a trust? Maybe when is it in general, right, terms, when is it a good idea and when it's not a good idea? What are your thoughts?
It depends on what you want it for. Depends on what your goals are. If we're looking to avoid probate because maybe we have property in multiple states, yeah, it's a good idea. Typically, that's a revocable trust. In general, you have either a revocable trust or an irrevocable trust. Revocable, it's not going to help you protect assets, not going to do any of that, but it's going to help you avoid probate, which may be a goal. So it's very valid. If that's what you want to do, you can have a revocable trust. If you're going to have an irrevocable trust, what are we using it for? Is it asset protection purposes? Is it for tax planning? There are a number of factors that we have to discuss with the client to make sure that's appropriate for them. And remember, if it's irrevocable, right? You're not able to change it. Now, there is something we can utilize called a trust protector, and the trust protector can change the terms of the trust, but the grantor, the settlor of the trust, can't just unilaterally go in and change the terms of the trust. It would have to be done through a trust protector. So it really depends on the purpose, what the client's goals are as to whether we should utilize a trust or not. And then how are we going to set it up from a tax perspective? And the attorney that you go to have this set up better understand the income tax rules as it relates to how they're setting this trust up. Otherwise, either the kids or yourself are going to be in for an unpleasant surprise when income taxes roll around. So there's 3 ways that a trust is taxed. Either it's going to be a simple trust, a complex trust, or a grantor trust. And we don't have to go into the intricacies of that, but the difference on income taxability and tax brackets within that trust can vary greatly.
Got it. I wanted to kind of circle back to having financial and healthcare power of attorneys. It just made me think of something else. One of the things that I'm big on when I'm talking to my clients is having an honest and open conversation with your family on what are your wishes, what are you trying to accomplish, what are you nervous about and scared about, so that way the whole family understands what do we need to accomplish. And let's say that the seniors have more than one child, right? Let's say there's 3 children. Is there any kind of, from the legal point of view, is there any better way to ask one of the children to be the power of attorney, or someone in charge of making decisions over others? Does my question make sense? Like, is there any pluses or minuses or any advice to that?
Yeah, I think just in general, the person that you choose, number one, obviously you need to trust them, or they shouldn't be on the document at all. Mm-hmm. And number 2, do they have good head on their shoulders? Are they making rational decisions? Are they good with money if they're going to be handling your finances if you can't handle your own? Do they know what your wishes are with regard to your health care? It's an important conversation to have. A lot of times clients will come in and they'll just choose the oldest child, which may not be the best choice just based upon age, but have a conversation with the child, let them know what your wishes are with regard to finances and health care. And, are they capable of handling those responsibilities? And if they're not, are they smart enough to go to a professional to assist them with that? So that's, I think, the best way to handle that. And to some extent, location may have, to some degree, may play a bit of a part of it. It's certainly going to be easier if the child is close to you, but that's not the only basis for which you should make your decision. Certainly, with everything being done electronically now, the POAs, even if they're out of state, the powers of attorney can easily act on the principal's behalf.
Got it. Thank you. That was a good answer. I understand, going back to Medicaid, that the way the program, even though it's a federal program, it works differently in different states. Can you cover a little bit about the difference between Medicaid in New Jersey versus PA, and what do we need to know?
Yeah, Medicaid is a federal state partnership. So the Fed kind of outlines the broad rules, and the states can tweak a little bit as they see fit. And there are some differences with regard to Medicaid in between New Jersey and Pennsylvania and other states as well. But Pennsylvania being very close to where we are here in South Jersey, there's going to be some overlap there. There's some differences in the assets that you're allowed to keep, asset values. In Pennsylvania, it's based upon your income. So you're either able to keep up to $2,400, or I think it's either $7,000 or $8,000, depending on what your income is. In New Jersey, the limit is $2,000. In New Jersey, Medicaid will cover care at home, in assisted living, and in a skilled setting, a nursing home. Whereas Pennsylvania, it's really more of a nursing home setting. There are ways that Medicaid can cover someone at home, but it depends on what the individual's income is and their expenses. And then you're not going to get that coverage from Medicaid in assisted living in Pennsylvania like you are in New Jersey. So there's some minor differences there.
Got it.
But it's something to take into consideration. I mean, if you're very close and mom or dad is in assisted living, I would take a look at both and see ultimately what's going to be the better course. If you're open to being if you're in Pennsylvania and you're open to being in New Jersey does certainly offer some benefits.
Got it. How do you feel about overall long-term care insurance? Is this something you're a proponent of? Can you give us some of your thoughts on that?
If it's in your budget, it's certainly good to have. I mean, the clients that we work with that have long-term care insurance, there's more that we can do because they have a different payer source. So if we want to start protecting assets immediately, we know we have a different payer source. But it's all going to come down to what your budget is and where you are in your life. So how old are you? Do you have pre-existing conditions? Because you're going to have to go through those underwriting requirements, and it's going to greatly affect the premium that you pay. And be aware that your premium is going to go up. It's going to go up. There's no denying that it's going to be raised. So you have to be prepared for that. And then what's going to affect your premium is how many years are you getting it for? What's the rate of coverage that you're getting? So how much per day is the long-term care insurance going to cover? What's your elimination period? It's typically, a 90 days or so, somewhere around there, but you can have a 0-day elimination period, or you can have a 12-month elimination period. So that's the period of time where you're going to private pay before the long-term care insurance kicks in. So that's going to affect your premium. And then what does it cover? Does it cover at-home care, assisted living, skilled care? How much? It's all going to be written into the contract. And some people, long-term care insurance has certainly improved over the years. It used to be where if you didn't use it, you lost it, right? There was no benefit. But there are riders that you can attach to it that provide a death benefit. So if you don't utilize it, there's a death benefit to the heirs, or maybe your spouse can use it. So there's a lot of things that you can do to play with it. And I would just have everybody, get a couple different quotes and see if it's within your budget and something you can afford. And it's certainly good to have, though, if you can afford it.
Yeah, I found personally doing the research and speaking to a financial advisor about long-term care insurance, it's very overwhelming because there's so many different plans and options. But what I do know is that they don't offer it for a lifetime anymore. I guess that's because it's just the baby boomer population is a large group, and they're probably just not able to financially be able to do that. So I found that a little daunting, but.
Yeah, we have a few clients that still have that unlimited coverage, which those are great, really great policies. But yeah, you can change it up however you want. It's gonna affect the premium.
Excuse me. Does the this rider policy, can it be added on to an older policy that you already have in Pennsylvania?
I don't know. You'd have to check with the individual the company that issued the policy. I would urge you to reach out to them and see if that's possible.
Okay.
Okay. What else do you think is important in, making your legal affairs, putting them in order? Is there anything else that you think, besides having the financial documents that we talked about, what else do you think families, whether it's kids helping their parents or, parents themselves trying to get things organized, what else do we need to know and do?
Yeah, it's hard with some of the children who are kind of caught between trying to help their parents out, still trying to take care of their own kids, which, as we all know at this point in time, is craziness, right? If the kids are at home and you're trying to juggle that with your own career and your job and taking care of your household and then taking care of your parents on top of it, it can be a lot. What we recommend to our clients, and it's really to anybody whenever we speak, is just know what your options are. Make sure that you reach out to someone and at least figure out what options you have, and then make an informed decision based upon what your goals are, whatever that may be. But make sure you understand what the law and what's going on, and don't go by what your neighbor did, because your neighbor that situation can be completely different. And don't go to someone who doesn't specialize in this area. Don't go to your nephew's friend who's a real estate attorney. Yes, he's an attorney, but maybe he doesn't specialize in this. And these laws, the Medicaid laws, the tax laws, estate planning, elder law, it's all going to overlap. And whoever is doing this for you, they have to have a detailed understanding of exactly what's going on to make sure that you're protected. And one of the things that we see a lot is, and you being in real estate, I'm sure you've seen this. Whenever mom and dad give that property away, right? Whether they're giving it to the kids, which we won't necessarily recommend, or we're going to utilize a trust, they can retain something called a life estate. A life estate means they have a lifetime right to the property. They can live there, they can rent it out, they continue to pay the property taxes, they get their rebates and deductions. If they don't retain a life estate, which is also okay, either way is okay, just depending on what the plan is. If you don't have a life estate and you've placed your property in trust, you don't own the property anymore. It's not yours. No tax freeze, no rebates, no deductions, none of that. You don't get that anymore. The issue that we run into a lot is that if that property is going to be sold, so again, remember Medicaid, if you've given away something and you didn't receive fair market value back for it, it's a gift. That can be a disqualifying gift. So if mom and dad have a life estate and the remainder interest is either in the trust or in the kid's name, and then the property is sold, we've yet to find a title company or real estate agent that understands that both parties get a check. It doesn't just go to the kids. The life estate has value. So if a portion of the proceeds don't go back to mom and dad, and then they file for Medicaid within that 5-year period, that's going to be considered a gift, which can be disqualifying. So in that instance, we have to calculate what the life estate is worth and what the remainder value is worth. And there should be 2 checks cut, one to either the trust or the kids, depending on who owns the remainder interest, and then the other one to the life tenant, which is potentially mom or dad or both of them. So unfortunately, that causes people some problems later when that wasn't disclosed to them what they should be doing. So, we want to urge the real estate agents and the title companies that if they see this, they need to be able to at least, issue spot a little bit and say, hey, what are we supposed to do here? Who's supposed to be getting a check?
So to piggyback on that, with the life estate, when something like this is created, are there any changes made to the deed?
Yes, when it's created. So if mom and dad are trying to move the property out of their name to protect it, we draft a new deed. The new deed says, to John and Sally as trustees of their parents' trust as the grantee. But then there will be a paragraph that says it's subject to a life estate for the grantors, which is mom and dad. So that clause gives them that life estate right.
Interesting. So when Medicaid, I'm just curious on this, when the Medicaid does the 5-year look back and they're analyzing everything, what is generally the time frame for that? Do you know?
For them to complete the process?
Mm-hmm. How long does it take?
Months.
Okay.
All the counties are so backlogged right now. You're not even going to get assigned if you're filing a Medicaid application, you're not going to get assigned a caseworker for a few months. And then the caseworker then will start reviewing the file and start requesting documentation. And they're going to the caseworker is going to give you a very short period of time to get them what they need. And if you don't, they're going to deny the application and you're back to square one and you have to start over again. But the entire process from date of filing to an actual approval is several months.
Which goes back to the same point as when I always suggest to everyone is be proactive, because it seems to me when I get involved is when people are trying to put out fires because they need to place their mom or dad in a home because of one thing or the other. And they're trying to do this. And what they don't realize is that just how long some of this process takes that they have no control over. And in the meantime, they're probably forced to do private pay, right, while they're waiting for the decision.
Right. And the, one of the other issues is the little things that people don't think about that is considered a gift. So number one, sometimes people confuse the IRS regulations with the Medicaid regulations. So the IRS says you can give away $15,000 per year per person and you don't have to tell us about it. If you give away more than that, you have to file something called a 709, which is a gift tax return, but there's no tax due on it unless you exceed your lifetime gifting exemption, which most people at this point, they're not going to do because it's about $11.4 million. So don't confuse those two, because Medicaid, that's not the case for Medicaid. Any type of gift could be disqualifying for Medicaid purposes. So we want to be careful of that. And then other little things that people don't think about that can be considered a gift is if mom is living with her daughter and mom is giving her $1,000 a month to offset the daughter's extra food, utilities, rent, things of that nature. If there's not a lease in place, that's considered a gift. There has to be an expectation of payment. Or if the daughter is buying things and mom is reimbursing her, if there's not a promissory note, that can be considered a gift if there's not an expectation of repayment. Because Medicaid will say, well, the daughter did that out of love and affection. She wasn't expecting to be repaid by mom. Or if they're providing caregiver services and mom is paying the daughter for taking off of work and taking her to her doctor's appointments and those types of things. If there's not a caregiver agreement in place, that's considered a gift. And during that 5-year period, we understand that if there's a gift there, then it could be disqualifying for Medicaid purposes.
Interesting. So it's better to have some kind of agreement, even if it's informal. This way, the financial arrangements are in writing.
Exactly. Right.
Got it. Okay. There's something else that I wanted to ask you, and then it slipped my mind, but I will think about it. Well, at this point, while I think about my question, I wanted to open it up to anyone who is on this workshop to ask questions. So if you guys want to unmute yourself, or you are welcome to put in the chat box, and then we will give it to Chris. Oh, and while people are figuring out if they have questions, here's mine. How long do you think overall, if all the documents are put together fairly quickly, how long do you think the planning takes place in terms of creating the necessary documents, legal documents to have in place?
How long does it take us to get everything drafted?
Mm-hmm. Like have everything drafted in place so that way you can say, yes, my documents are in order.
I would say, right now we're probably on about a 4-week turnaround.
Okay, so it's not something that takes 3 to 6 months.
No, not unless you're extremely complicated.
Okay.
No, if we're just doing basic wills or a trust and POA, healthcare POA, those 5 basic documents, it'll take us a few weeks. What we do is we have the client, either they come into the office or we can do a Zoom call. and we go through what they have, assets, liabilities, children's information, what their goals are, what are they trying to accomplish? Are they providing for grandkids? Do we need a testamentary trust for those grandkids that are under the age of 18? Are there IRAs in place where maybe we're doing an IRA trust? Get all of that information, get their fiduciaries in place, get everything drafted, send it over to them for review. They come back with any questions, we make any changes, they come back in, we go over it again together, and then they can execute their documents. So you're looking at about 4 weeks.
So I think my message here is that this is not something that takes years. It's just if you decide to do this and you get all of your paperwork in order, this is something that can be accomplished in a relatively short period of time. I don't consider 4 weeks a long period of time, but at least that will give you the peace of mind knowing that you're prepared. Because as we know, things can happen overnight. So which happen more.
And it's, and it's very easy. These aren't fun things to do, right? It's very easy to put this on the back burner and keep procrastinating. But sometimes that's where people get in trouble, is that procrastination. And then a crisis occurs, and now what are you going to do? Because what happens if dad has a stroke and now he becomes incapacitated and there's no power of attorney in place? You don't have the ability to access accounts, to sell real estate. You can't do anything. Now we have to go to court to get a guardianship, which is a much more lengthy process and more expensive. And now we have not only one attorney involved, now we have two attorneys involved, because the court appoints an attorney to represent the incapacitated person to make sure they're not taken advantage of. And that's appropriate. But now that attorney also has to be paid. So now you're looking at thousands of dollars in legal fees. And if you just would have planned ahead a little bit, just get it done. Like you said, it takes 4 weeks. You're finished with it, put it away, revisit it in 10 years,
Right.
5 to 10 years.
I completely agree. No procrastinating, because that's when usually I get involved, is when people are putting out fires and they have a crisis on their hands, for sure. Yeah.
Right.
All right, everybody. Anybody has questions for Chris? Awesome opportunity to ask whatever's on your mind.
Is there a difference of tax-wise for the children if the money's in trust or not in trust?
That's a good question. So from a tax perspective, so the question was, from a tax perspective, is there a difference to the beneficiaries if the money is in a trust or not? It depends on what state you live in, depends on the type of trust it is. In Pennsylvania, even if children inherit either through a will or a revocable trust, there is an inheritance tax. In New Jersey, it's based on the class of the person. So a Class A individual in New Jersey is a spouse, a parent, a child, a grandchild. So there's no New Jersey inheritance tax for a Class A beneficiary. But if you start giving things away to brothers and sisters, nieces and nephews and friends, then there is the New Jersey inheritance tax. So that's on anything that you own that's in your name or held in a revocable trust. Now, if it's in an irrevocable trust, then now it depends, right? Because it depends on how the trust is set up. If the trust is going to cause inclusion in the estate, then if you're a non-Class A beneficiary in New Jersey, then there would be a tax, an inheritance tax. If there is no inclusion in the estate in the way that the trust is drafted, there's not going to be a New Jersey inheritance tax, but there could be a federal capital gains tax depending on what the unrealized gain is of the appreciating assets in the trust. So it depends on what the cost basis is. So if you transfer an appreciating asset into an irrevocable trust that does not cause inclusion in the estate, there is no step up in basis. There's a carryover basis. So if the kids sell that appreciating asset, there could be a capital gains tax there. So it really depends. Assets that are received through an inheritance typically are not subject to an income tax, though, unless it's a qualified asset like an IRA or a 401k or 403b. Then when the child and when the beneficiary takes the money out of the qualified form, then there's an income tax associated with that.
We need an accountant to translate a lot of this.
It seems daunting and it's a lot of information, but we think that you should just sit down with us and we can go through it step by step, because you don't know what you don't know. You don't know what questions to ask. And sometimes those are the issues that people have when they try to do it themselves with some of these online forms, is they get into trouble because they don't know exactly what they're doing or the questions to ask. So whenever we meet with the client, we run through a host of questions, and it's just sometimes things that they've never thought of before. And they have to take some time to think about it.
Okay. Thank you.
If the parents live in Pennsylvania, say, and the kids live in New Jersey, after at the time of an inheritance, do they have to pay inheritance tax in New Jersey on a Pennsylvania estate, or vice versa?
Good question. Where the decedent was a resident. So if the decedent was a resident of Pennsylvania, then Pennsylvania law is going to control not where the beneficiary lives. It's going to be based upon the residence of the decedent. Now, there could be, let's say that parents lived in New Jersey, but had some real estate in Pennsylvania, then there would be a Pennsylvania inheritance tax on that real estate. But there may not be a New Jersey inheritance tax if they're all Class A beneficiaries. So it all depends on where the individual lived when they passed away. What was their state of residence?
On a Medicaid situation, are there certain assets in Pennsylvania? We happen to live in Pennsylvania. Does Medicaid come after, for example, an IRA or a retirement asset that the person who goes in a nursing home owns? Do they come after everything, or some assets exempt?
Some assets are exempt. Depends on what state you live in. That can vary a little bit, and depends on whether you're married or not married. So there's some factors there that some assets could be exempt, some may not be exempt. It's all very fact specific in that situation.
Well, we do live in Pennsylvania.
Yeah,
And
I would say if I would need to know more about the situation. From the names on the screen, it appears that you're married. So when you're married, there's something called a community spouse resource allowance.
Yeah.
So typically it's half of the assets, but it's subject to a ceiling. And that ceiling, I know in New Jersey, I think it just changed. It's about $130,000 now. It's just changing over. It was 128, I believe, and I think now it's 130. So if you have $200,000 in assets, the well spouse, the community spouse, is only entitled to keep 100,000. The other 100,000 is at risk. So that's what we're looking to protect. Or if you had $500,000 in assets total, then that community spouse is capped out at the maximum, which is about $130,000. The other, $370,000 is at risk. So that's what we're looking to protect. So it's going to depend. And there are different ways that we can protect those assets.
Mark has a question about having a ballpark estimate of a cost to set up a trust to avoid probate for a second home in Florida.
Ballpark, if you're looking at a revocable trust, a pour of a will. So you still have to have a will, but what it does is it pours it into the trust. So you have a revocable trust, a pour of a will, power of attorney, healthcare power of attorney, living will, HIPAA release. Just fairly straightforward. You're probably $2,500 or so.
So that would make it 5 documents plus the trust setup, right?
Yes.
Okay.
Correct.
And that was then the other question, just to clarify, because I know in working with a lot of other attorneys is that a lot of the times is billed on a hourly basis. However, when you're preparing this kind of paperwork, is that a fee for getting everything done that is a lump sum versus hourly rate?
Yeah, it's typically a flat fee.
Flat fee,
Mhm.
okay. All right, that's helpful. All right, anybody else has any other questions? Chris, is there anything else that you think we should know? I, as a child of parents, need to know just to, ease my mind because this is a lot. This is actually one of the reasons why I am, doing these workshops is to help myself and others who are on this journey of helping their parents and parents
Yeah.
helping themselves getting more info.
It's not, you as a child, it's not always an easy conversation for you to have with your parents because you may feel like it's none of your business. You may feel like you're intruding on them. You may feel guilty because maybe you think that they think that you're trying to get their money. It's not, it's just an open conversation. You shouldn't have any guilt about that. It's just a way, because again, they don't know, they don't have this knowledge. So it's just a way for them to understand what the options are. And then their choice is their choice. If they want to protect some of the assets for the kids, then they'll do that. If they don't, and they say, hey, you're on your own, then they keep their assets. But figure out, make sure your documents are in place at a minimum, and then figure out what your options are moving forward. Do we want to protect something for that spouse in case something happens to one of us? Do we want to protect something for the kids? Those are the conversations that you can have. And it's not a matter of you intruding. It's just a matter of, hey, mom and dad, just, and you don't have to go with them. They can go on their own. They can come to us on their own and just figure out what your options are. And then they do whatever they feel is most appropriate for them.
Good advice. I agree. All right. Anyone else has questions? I think Don and Barb has something else.
You have an accountant on your staff?
We,
Sounds like one is needed.
we don't. We handle everything with the exception of an income tax return. We don't do personal income tax returns. Everything else we assist the clients with, even on a tax perspective, we provide guidance for them. If you need a referral to an accountant, we can certainly give you one, but we try to lay it out as easy as we can and make sure you have the knowledge that you need so you can make a decision.
All right. Anybody else has anything else that they want to ask Chris about? Well, if nothing else, Chris, again, thank you so much. Very much appreciate you spending the time. This has been very much helpful for myself as well as I hope for others. And we hope you have a great rest of the year. And we will forward your contact information to everyone if they want to get in touch with you, get a hold of you, and then ask more questions maybe as they come. Okay?
Yep. And they could call our office. Our number is 856-857-6007 or BrattonLawGroup.com. Yeah, we'll be happy to answer any questions that they have.
All right, perfect. All right, well, thank you so much,
Thanks.
everyone. Have a great day. Thank you, Chris.
Thank you. Take care. Be safe.
Thank you. Bye-bye.